Moving on with the next speaker, we are honored to welcome Mr. Elias, an accomplished lawyer, lecturer, and international arbitrator with over 2 decades of distinguished legal practice. As founder of Ghanem law firm in Beirut, Lebanon, Mr. Ghanem has built a premier legal institution known for its excellence in advising both local and international clients. He serves on the arbitration committee of the Beirut Bar Association and the executive board of the Lebanese International Arbitration Center, and plays a key role in global arbitration policy through his work with the Chartered Institute of Arbitrators in London. His expertise span international business law, banking and finance, corporate and commercial law, privacy law, and international dispute resolution. A certified integrated risk management and artificial intelligence professional, Mr. Ghanem also advises multinational corporations on GDPR compliance, data governance, and AI-related legal frameworks. He has served as an arbitrator in numerous institutional and ad hoc proceedings and is affiliated with leading arbitration centers including SIAB, CPIANI, LAAC, BBA, LAMC, TIAC, and CAMC. In addition to his legal practice, he lectures on AI, ethics, and principles at the American University of Beirut. We are delighted to welcome him today as he elucidates the realm of ADR in Lebanon, offering the valuable perspective shaped in his extensive experience and leadership in this field. It's over to you, sir.
Hello, good morning. Thank you so much for your introduction. Good morning for distinguished colleagues and arbitrators and friends all over the world who are listening to us today. Firstly, it is an honor to address you today at this prestigious forum. Lebanon is an arbitration-friendly jurisdiction. Its arbitration legislation is modern and embraces well-established principles of international arbitration. Investors and business actors in Lebanon increasingly include arbitration clauses in their agreements to benefit from the ability to choose their arbitrators, the speed and the flexibility that is offered by arbitration, and the confidential nature of arbitral proceedings. We are now also adding to the arbitration scope the regulating oil and gas investment in Lebanon, among other things, of course. Because we have oil and gas in Lebanon, and it has been regulated during the 5 past years. So I will try in this session to explore 4 main points regarding, first, the legal safeguards protecting international investors, key trends shaping commercial arbitration, the role of Lebanese courts in supporting arbitration, and of course, if there is some critical reforms needed to modernize our framework. So what is a legal framework that protects international investors in Lebanon? Lebanon offers a dual shield for investors: international treaties and domestic legislation. For the international treaties, we have 52 bilateral investment treaties, and 43 of which are still in force. So we have more than enough to have a good protection for investors through those treaties and conventions. And we have to add that Lebanon is signatory to the GSADRT Convention and the New York Conventions. The GSADRT, which means the Washington Conventions, and the New York Conventions in the recognition and enforcement of arbitration abroad. So Lebanon signed also many other treaties, regional and multilateral agreements. So for the investors, it's the main point here. There is a big issue in the matter of protection. He is very much protected by those multilateral and bilateral agreements and treaties. The other shield or protection for investor is not only the treaties and convention. We are going to the Lebanese investment law itself. We have in the 2001 a new law based on investment to encourage all investors from all around the world to come and invest in Lebanon to benefit from its provisions of this law, of course, because all Lebanese bilateral investment treaties contain arbitration clauses. So this law created a public authority named IDAL, Investment Development Authority of Lebanon, a legal entity enjoying administrative and financial autonomy. This new body has promote and he can sign agreements with any investor regarding matters regarding to agriculture, agri-food, tourism, information technology, telecommunication technology, and media sectors. So it is a wide scope to invest in Lebanon, and it could be regulated and under the supervision of the government, the Lebanese government. So we have, for this matter, it's very important to know that we have an arbitration clause that refer to arbitration on all investors' case. Any case in Lebanon with investor must be under arbitration to protect them from any problems in the futures. So Lebanon has been subject of a few investor-state investment disputes. Recently, after the economic crisis in Lebanon, we have been five recorded cases in which Lebanon has acted as a respondent under the EXID and one under the Cairo Regional Center. So we have some dispute regarding the investment in Lebanon. One of those disputes, the tribunal dismissed the a Greek company claim under EXID. Under EXID in 2024. And we have still other dispute, which is very important to mention. We have a big investor in Lebanon, an Emirati investor, which is Haptour Group, issue a notice of dispute under the UAE Lebanon bilateral investment treaty against the Lebanese public. So we have precedents in Lebanon. We have many cases regarding the issue of investment in Lebanon. So the investors can recourse to the EXID or the Cairo or any other place where you have the favorable place for arbitration for them. They can choose a seat, they can choose the institutions as well during the drafting of the contract with the Lebanese government or through the IDAL, which represent the Lebanese government. So this issue, I'd like to highlight on it because it promotes for investors to come to Lebanon to look into its regulations for new investments during this new laws in Lebanon. The second subject, which is important to highlight on it, it's the key trend and development in commercial arbitration. You know, it's not only in Lebanon, in most places in the world, you find that we have a growth of institutional arbitration. The main thing in Lebanon that we don't have a lot of arbitration institutions, which is primarily looking in commercial arbitration. We have 3 or 4 institutions, but the most important or the primary one is the Lebanese Arbitration Center of the Chamber of Commerce, LAMC, which was founded in 1995. So this center is important to look into it and to discuss some matter regarding its rules. We have a new rules in 2024. They look into to align with the need and practice of modern arbitration, such as procedures, for complex disputes, shorter time limit for challenges, interim measures, place of arbitration. It should be done or determined by the tribunal, not the court, if not agreed by the party. Emergency and expedited arbitration, which is very important. We look into it on many international arbitration institutions all over the world. You find that we are looking to minimize the cost and fees on any parties that are looking to settle their dispute in arbitration. So the emergency is important to expedite the proceeding as well. For the expedited arbitration, it is important to have a limit short time to settle dispute without paying a lot of money. So we have such centers in Lebanon. We have as well for the ICC, we don't have a place for arbitration, but we have a national committee that look in appointments of local arbitrators. We have the Chartered Institute of Arbitrator London, which I'm honored to be part of it, which is looking for education and training only in Lebanon. She doesn't look into settling any dispute in Lebanon in this matter. We have a new important center, which is the LIAC BBA, which under the paramount of the Beirut Bar Association. I've been honored to be one of the founder and executive board member. For more than 6 years, I work on drafting the rules of the center and promoting for arbitration in Lebanon. So it is an important center looking for arbitration as well. The important thing that has to be highlighted as well is the digitalization and remote hearings. It's not only for Lebanon. We know it's a new practice in arbitration that it depends to the tribunal to decide how to have a video conference and remote hearings. And the digitalization has been more and more implemented on the proceedings of arbitrations in Lebanon and elsewhere. So the parties to the contract should not hesitate to use this ODR out of fear of non-admissibility and or they are a fear of unenforceability of the arbitral proceedings at all. It will be enforced and the award shall be recognized by Lebanese courts. So this matter is very important regarding the trend and development in commercial arbitration. I will shift to the third point, which is the influential ruling by local courts impacting arbitration. It's not only Lebanon who have impact from local courts, which depends on certain degrees. And of course, we have many kind of intervention by the local courts. The main issue that courts play a vital, yet sometimes contentious role. First of all, the domestic courts support to the arbitral proceedings. The second issue is the intervention in case of forgery allegation. The third, the provisional relief, and the fourth, the recognition, which is very important to recognize and enforce the award. So in this matter, we have to highlight on many things in the matter of intervention of domestic courts in Lebanon. In supporting the arbitral proceedings, the president of the court of first instance may act as the judge in support of arbitration. Regarding appointment of arbitrators where parties have failed to designate an arbitrator, or where there is absence of an agreed set of institutional rules containing a default mechanism. So the domestic courts had the role to support the arbitral tribunal. And on the second point, it could intervene. The arbitrator shall suspend on domestic arbitration, the arbitrator shall suspend the proceeding in matter of forgery allegation. This matter is very important to highlight. We have international arbitration and domestic arbitration in Lebanon. Regarding the domestic arbitration, any allegation regarding forgery, the tribunal shall suspend and his proceedings till we have a settlement on, not settlement, we have a final decision on this matter. So it is important to highlight on it because it is different than the international arbitration. If there is a forgery allegation before an international tribunal or international arbitration, the principle applies in international arbitration unless there is an agreement to the contrary. If the party mentioned that in case of forgery, then the tribunal shall continue to go through the proceedings, then it will be it will not be pending at all, and we continue till we receive an award. So it is important to mention for legal practitioners, once we have a draft in Lebanon, to mention this exception to limit any guerrilla tactic regarding forgery allegation. So on this matter, we have a domestic court as well to provide provisional relief. We have two kinds. The tribunal, if is not yet constituted, so they can give relief in support of the arbitral tribunal before the judge of summary proceedings, which can be done on ex parte basis. You know, we don't have to notify the other party. After the constitution, maybe the tribunal will ask the local judge to maybe to sanction witness who fail to appear at hearing, or those who refuse to testify, or interim attachment order to freeze assets. So there is many things that can be included in this matter and supported by the local Lebanese court. So we have another recognition and enforcement award, which is very important as well. This point is a matter of the recognition of the domestic award and the international award, international arbitration. So we have both of that. To have a international arbitration award recognized in Lebanon, it records against, you can have an exequatur from the judge in Lebanon in order to execute or to enforce this award. Of course, we have many challenges of this matter. It could be, I will not go through it now, but in matter of enforcement, it could be enforced. And in matter of annulment as well, if there is a challenge of arbitral awards, when is conducted, if the arbitration is conducted on ex equo et bono, the arbitral award cannot be appealed. But we have to highlight on other issue that in an international arbitration, appeal is not an available recourse, and the arbitral award can only be subject to a setting aside action, which is very important on this matter, because the setting aside action are considered public policy and cannot be excluded by the parties' agreement. If the party can include in their during drafting of the arbitration agreement or arbitration clause that there will be no appeal on the decision of the judge, the award of the tribunal, then you don't have to go to appeal. But if they don't say that, maybe one of the party will go to the appeal. So, and the most important thing is that you cannot agree at all, internationally or domestic arbitration, to insert a clause where you say that an award, you cannot refer to the objection or the challenge to set aside an arbitration award. Always you have the option as one of the party to challenge the arbitral award. This matter for awards rendered in foreign jurisdiction, there is a matter of granting an exequatur, as I mentioned, and the appeal against the decision granting exequatur if someone didn't have the option to execute it because the court refused to give him an exequatur, he can challenge it and appeal before the court. So all is regulated regarding the challenge and the enforcement in Lebanon of those of the awards. But the main issue that I would like to highlight on it is that we don't have a lot of grounds to object or to challenge. It is limited in the international aspect on 6 only. If it was rendered, the first one, if the award was not rendered, it was rendered without an arbitration agreement. This is a ground for challenge, or on the basis of an agreement that is null or void. Let's say we have one of the arbitrator didn't take an extension of time during the proceedings, and this will happen many times if someone is not aware for the time limit to finalize the award. So this matter will be subject to setting aside the award. So it's very important to highlight on this issue and to take the time limit in consideration. If the award, if it was rendered by arbitrator not appointed in accordance with the law, and if the arbitrators ruled without complying with the mission conferred upon them, if it was issued without due respect to right of defense, so due process and equal treatment between parties is very important in arbitration. Otherwise, it will be subject to setting aside the award. If it violates a rule of international public policy, it's very important when we are talking about international arbitration. International arbitration is subject to international public policy, not to local public policy, which means a friendly, arbitration-friendly concept in Lebanon. Any award, if it is against local subject policy, it couldn't be challenged. It must be against international public policy. That means international standard regarding public policy, which is very good on this matter. So we have many examples of Lebanese courts that have set aside awards for procedural irregularities or violation of public policy. We have many precedents under the Court of Cassation. Every year, I think we have a new jurisprudence on this matter. The fourth point that I would like to explore it with you is the current challenges and the critical issues in arbitration landscape. So it's not the matter only what we have, it is the matter as well what we have to do, because we have a new situation now. We are in a new era of AI, so how to look into the future, how to correct if we have some things to make it better. As a member of and the reporter of the Special Committee of Arbitration in Lebanon, tasked with crafting a proposal to the parliament to enhance the current Lebanese law on arbitrator. It is an honor for me to be part of this special committee. Many concerns and challenges is facing arbitration and must be considered in a new amendment of a new law. The arbitration landscape faces several challenges and critical issues, particularly with our country's economic crisis, political instabilities, and outdated legal framework. So we know, all of us, that our law is based on French law as well on the ancestral model law. But there is many things that had been amended in the new model law and is still outdated in our law. So if I have to highlight on such many points that has to need reforms, first, lack of sufficient judicial support for arbitration. I mentioned that we have support, but it's not enough for our future. There is delays in court interventions. We have excessive judicial interference, maybe in reviewing the merits of dispute when deciding on annulments. So it's a matter that has to be regulated because it has to be looked only on matter on the 6 grounds that I mentioned it, not on the full merits, because it will be excessive judicial interference. Another matter is the recognition of arbitration agreement. So not all Lebanese courts is agreeing to accept all kind of arbitration agreement. So it is a violation for the competence principles. There is outdated ground as well for annulment. It is broader than those under the ancestral model law and include vague standards how to explain a violation of public policy. So we need to amend this matter as well to be more consistent with the new model law. So the needed reform will narrow the annulment ground to align with international standard. And it will be examples only on for procedural defects, lack of jurisdiction, or serious public policy, international public policy, not local public policy. So we have another point regarding the enforcement challenges, difficulties in enforcing awards because we have bureaucracy, inefficiency, and political interference sometimes that maybe is affecting the arbitration's outcome. For foreign awards, sometimes delayed due to judicial reluctance to improper application of the New York Conventions. So we need as well a reform on matter of enforcement. Clarifies that court should not review the merits of awards when enforcing them. So it is very important only to look at it on prima facie. And another issue is the arbitration independence and challenge proceedings. We have it in the articles of the CCP, which is the Arbitration Act in Lebanon. The current rules on arbitration challenges are vague. We don't follow the IBA guidelines on conflicts. So we need a reform that adopt clearer standards for arbitrator impartiality. And we need as well, I recommend it not only for Lebanon, but for every practitioners and for every government in the worldwide, the lack of specialized local arbitration institutions on the new science like blockchain and fintech. You know, we have more than tens of centers on every country, but we don't have specialized institutions that look into the new science of fintech, blockchain, or AI. So all those things must be specialized within special institutions. So I will look forward to have it in Lebanon, and I would like to see it in other places in the world. We have another issue which is important, the matter of the impact of economic crisis on arbitration in Lebanon, because you know we had a banking restrictions and an informal capital control. Parties had struggled to pay arbitration fees in foreign currency, hindering the proceedings. But now this solution is more and more simplified, and we can say we passed this critical moments. Finally, and as a conclusion, Lebanon has long recognized as an arbitration-friendly jurisdiction, and with targeted modernizing of its legal framework, and it can reclaim its status as leading regional hub for arbitration by limiting judicial interference, streamlining enforcement proceedings, and aligning with international best practice. Lebanon can strengthen confidence in its arbitration system. With the right updates, Lebanon is poised to become a premier destination for arbitration, reinforcing its legacy as a progressive and trusted legal jurisdiction. Thank you so much for your time.
Thank you, Mr. Elias, for quite informative, unique features about the Lebanese arbitration jurisdiction. And congratulations for being part of the committee which is working on the international arbitration proposed amendments in Lebanon. And it will be a really wonderful opportunity for KFCRI, the other knowledge partners to have you in this platform and sharing a unique quality about less intervention of courts in arbitration. Thank you. Thank you, Mr. Elias.
Thank you. It's an honor. Thank you so much for your kind invitation. And I'll be more than glad to assist with you on any other panels. Thank you so much.